Hello, Ben Bierce here with Revelation Cellular Forensics. In last month's blog, I covered sending the warrant or subpoena to the phone company to obtain cell phone records, but that was more focused on criminal cases. This month's blog will cover some clarification and specific information for civil cases. The first area I want to cover is who can send the subpoena. In a criminal case, as a police detective, I could write the warrant, take the warrant to the judge for signature, and then send it directly to the phone company. In a civil case, I can't do that. The attorney that I'm working with must send the subpoena to the phone company. This must be done under the supervision of the court, and most of the time there needs to be an open court case before the attorney can do the subpoena for phone records. Some jurisdictions allow for pre-complaint discovery, and the subpoena can be sent before the case is filed in court. Indiana, for example, allows for miscellaneous cases. An attorney can approach the court and request a miscellaneous cause number for pre-complaint discovery, and then send a subpoena under that miscellaneous cause number to the phone company. The next subject is, how do I identify the phone company based on the phone number? If we know the phone number for the records that we want, how do we know what company to send the subpoena to? There are tools for law enforcement to exactly identify the phone company for a given phone number at a given time. Unfortunately, for civil cases, we're limited to open source searches. One of the best tools is Local Calling Guide, and I'll have a link down in the description. This tool will show us the original phone company that phone number was assigned to. This is a good place to start, but it doesn't guarantee that the phone number is still with that phone company. Customers can change their phone companies and take their phone numbers with them. Another valuable tool is the reverse phone lookup at Whitepages.com. Again, I'll have a link in the description. The phone company that Whitepages shows in its search results may be the current phone company for the phone number, or it may be the original phone company for the phone number. If the phone number had been ported several times to different phone companies, the results in Whitepages may be any of the companies along the line. Whitepages isn't perfect, but it is a valuable tool. These tools aren't perfect, but they are a good start. A good practice is to send a preservation letter to the phone company identified in the open source searches, and then follow up in a few days with a phone call to confirm that that phone company is the phone company that had that phone number during the time frame we're looking for. The phone companies will usually tell us if that phone number wasn't on their network. Another valuable technique is to ask what the phone company is in the interrogatories to the owner of the phone. It's important to ask what the phone company was at the time of the incident and not necessarily at the time of the interrogatory. For more information on identifying the phone carrier, see my April blog post, Identify the Carrier. I'll leave a link in the description. The next subject is, are the records available? Before we take the steps of submitting a subpoena to a phone company, we should know whether or not they are likely to still have the records. Many times in civil cases, we don't know that we need phone records until months or years after the incident. Policies on retaining phone records can vary by phone company. United States Criminal Code 18 U.S.C. 2703 requires that each of the phone companies keep their records for at least 180 days. Most companies keep these records much longer. For example, AT&T keeps all their records back to July of 2008. Sprint says they keep their records for 18 months, but I've had success up to about 2 years. T-Mobile and Metro PCS, which are one company, also keep their records for about 2 years, and Verizon keeps their records for about 1 year. Let's say, for example, that we were engaged on a new case, a motor vehicle crash, and we were engaged on August 1st, 2019. And let's say that the crash occurred on June 12, 2018. If the phone for the records that we want was a Verizon phone around this time, the records would not be available. Verizon only keeps those records for 1 year. But if this were an AT&T, Sprint, or Metro PCS or T-Mobile phone, they would still have the records. If we're only looking for the call logs, the phone companies keep these records much longer. But the call logs will probably not contain some of the valuable information we might want, like cell tower location or the actual seconds of the time of the call and the duration of the call to the seconds. Next is, what information is available? If you see my preservation letters, you'll see that there's a lot of information available from the phone companies, but not all of this information is kept for the 180 days required by 18 U.S.C. 2703. All of the phone companies will maintain the call, text, and data records along with cell site locations for the time periods that I mentioned before. Some of the information, however, is not covered under 18 U.S.C. 2703 and is deleted earlier. For example, Verizon maintains the content of the text messages. That's what the text message actually said, but it only keeps it for about 7 days. Verizon also maintains the estimated precise location of the phone at the time of an event. This is called RTT in round trip time or range to tower, but this is only kept for about 7 days also. That means that Verizon can recover the content of the text messages or the RTT for the 7 days prior to receiving a subpoena or a preservation letter. As a police detective, I usually knew within 7 days whether or not I needed a subpoena or a search warrant on a particular phone number. As a matter of fact, most of the time I could write the search warrant, have a judge sign it, and send it to the phone company within 24 hours of the incident. That timeline is unrealistic in civil cases. Only on very rare occasions do we ever know that we need text messages within 7 days of an incident. So in most cases, we don't need to include the content of the text messages or the RTT in our subpoenas to Verizon. No other phone company maintains the content of the text messages for any length of time, but some of the other phone companies do include an estimated precise location for the phone. AT&T keeps NELOS or Network Element Location Service for about 30 days, and Sprint keeps PCMD or per call measurement data for about 14 days. In most civil cases, the important information will be the call, text, and data logs along with the cell site location. And that information will be kept in the timelines that I mentioned before for each of the phone companies. AT&T is the only phone company that maintains cell site location information for calls, text, and data. Sprint maintains cell site information for calls and data connections. T-Mobile and Metro PCS maintain cell site location information for calls and text messages, and Verizon only maintains the cell site location for calls. The next area to cover is, do we need the account, subscriber, credit, and billing information? While extremely valuable in a criminal case, especially one where we know a phone number but we don't know who it belongs to, the account, subscriber, billing, and credit information can be extremely valuable in helping to identify that person. This account information is usually not as valuable in civil cases. We usually know who the phone number belongs to. We may have learned of this phone number through crash reports or interrogatories, so the association between the person and the phone number is usually well established. So we usually don't need to include this information in the subpoena. If, however, the user of the phone number is in question, we may want to request this account information to help establish the association between the user and the phone number. If we believe that the user of the phone number had other phone numbers that weren't disclosed to us, we may want to ask the phone company for any other phone numbers on the account. Here's a quick note. In interrogatories, make sure we ask for all the phone numbers used by the user. Next section is, what is an MVNO? An MVNO, or a mobile virtual network operator, is a phone company that provides services to its customers but doesn't operate its own cellular network. These companies, such as TracFone, Straight Talk, and Simple Mobile, contract with the larger carriers who operate the networks, like AT&T or Verizon, to buy wholesale minutes and then resell them to their customers. Our open source searches for the phone company will reveal the major network carrier like AT&T or Verizon and not the MVNO. At first, this won't matter much to us. we need to address our subpoenas to the major network carriers like AT&T or Verizon. That network carrier will have the call, text, and data logs along with the cell site locations. But the major network carriers most likely will not have the subscriber information. We need to send a subpoena to the MVNO if we want that subscriber information. Usually the return from the major carrier will include the MVNO as the subscriber information. The MVNO may have a call log, but they definitely won't have cell site information. If a person identifies an MVNO on an interrogatory, we may need to conduct an open source search to find the network carrier. Some MVNOs only use one major network carrier, like Cricket is only on the AT&T network. Boost and Virgin only operate on the Sprint network. But MVNOs like Straight Talk and TracFone use several different network carriers. Usually, for one account, they will use one major network carrier. But in a certain area, other customers with the same MVNO might use different network carriers. In conclusion, I can't cover all the issues in a single blog, but I've covered some of the more common issues faced by my clients. Every case is unique, and I'm sure someone watching this video will encounter a situation that I haven't covered. Don't hesitate to contact me so that I can help you through this. For starters, you can download the free preservation letter examples from the Revelation Cellular Forensics website, and I'll include a link in the description below. Thank you, and have a great day.